the Legal Corner, we're continuing the municipal liability series on the issue of lawsuits against schools. But more specifically, the legal steps taken when a teacher is involved in the molestation of a student. David Lesch, our legal analyst, is here to explain a little more on that topic. David, as always, thanks for being with us.
Good morning. We're continuing our municipal liability series, shifting from subways and buses in different places to school now, school liability. But when we're talking about governmental actions and we're talking about schools, we're also in some respects going to be talking about some private schools also, which don't necessarily involve the government. But when we're talking about public schools in New York City, we're discussing in particular not actions against the city of New York, they're actions against the Board of Education. And those are the actions where you still have to file a notice of claim within 90 days, and you still have to bring an action within a year and 90 days of the incident. When we're talking about the private schools, again, we're not discussing a notice of claim. You don't have to give a notice of claim to a private school, but you do have a certain time limit, 3 years, to bring an action, a statute of limitations, just so we're clear on what we're talking about here.
Okay. Let me just ask you something, though. You mentioned that it would be an action against the Board of Education, not against the City of New York.
Correct.
But is not the Board of Education now an agency, if you will, within the city structure?
Well, most people think that if you're bringing an action against the City of New York that you're covered for an injury that happens in the school. You're not. If you sue the City of New York for an incident that happens in a school, the case will be dismissed because you must name the Board of Education.
But you can bring the city in as a third party.
The city in effect is taking over the defense. But if you don't name the Board of Education in the summons of complaint, then you will have no cause of action.
Okay.
So you have to name the Board of Education. It's very important. A lot of people don't know that.
Okay.
Board of Education must be named. So in terms of where we're going to be, in terms of going forward and discussing actions against schools, in particular the Board of Education, today's segment we're going to discuss a difficult topic. It's teacher molestation. It's in the news all the time. I heard something about happening last week. There's always an incident where a child's been taken advantage of by a predator, usually hiding within the school system. It's a terrible thing that we have to deal with. It's terrible for the child. It has lasting effects, psychological effects, and once it comes out, the child ends up having to relive it through the police interviews, prosecutor who builds a case up against the predator, court testimony. So it's really just it's a horrendous thing to have to deal with. The issue is, you can always bring an action against the tortfeasor, the molester. That's not difficult to do. There are very rare cases in the law in New York where you're not allowed to bring an action against somebody who does you wrong, right?
Mm-hmm.
The problem is, getting the financial monies from somebody who does this to you to pay for the psychological treatment, the pain and suffering, that the quality of life that you've lost. Well, it's not so. Usually, the teacher, whoever does this to you, it doesn't have the financial resources to pay for whatever damage that has been done. So where do you go? You go for the deep pocket. You go for the place where you think you can get the monies to pay for the injuries that you've suffered. And certainly, if the Board of Education knew or should have known that this could have happened to you, that's where the actions are brought. Am I correct?
Yes, you are.
Okay.
Yes,
so the question is, how do we hold the Board of Education responsible for the action of somebody who does this to a child? Now, I'm going to tell you about a case. I'll give you a case, I'll give you a fact pattern, and then we can discuss the problems that ensued as a result. All right, so we have a child's in school, taking some drawing class, comic book drawing class. The Board of Education brings in a volunteer from outside to help the student draw and learn. The child has potential.
Okay.
Well, sure enough, the volunteer suggests coming to his home outside of class to give some extra tutoring. The mother doesn't think it's a problem because the mother wants the child to become a terrific artist.
Okay.
The volunteer is supposed to be well regarded within the community. First time nothing happens, but by the second, third, fourth time, the child is repeatedly molested. Basically threatened, don't tell anybody, nobody's going to believe you, the typical scenario that happens with the predator. Eventually, the teacher, or should I teach, the volunteer, is arrested for molesting another child. And when the parent finds out, questions her own child, and sure enough, the child basically says, yes, this has been happening to me, which is, usually the child's ashamed. You have to kind of pull it out of the child many times.
Sure.
So this parent, on behalf of the child, brought an action against the Board of Education. The Board of Education put forth 3 defenses. Okay. Number 1, no, we didn't do a background check on this particular volunteer, but a background check wouldn't have showed anything because he didn't have a prior background. And number 2, this didn't happen on school property. And number 3, you consented to this child going to the person's home, you the parent. The court bent over backwards to dismiss the case against the school based on those 3 defenses. The court agreed with all 3. The background check wouldn't have showed anything. Didn't happen on our school, and you consented to him coming over to see the child. Which means that these cases are difficult cases to prove because the negligent hiring is what encompasses the cause of action, and that you have to show that had a background check been done, or a background check was done and it wasn't done properly, that it would have showed that this person had some type of negligent or some type of criminal history that would have alerted the school that this would have been happening. But it's more than that. You now have to show that it happens in the school, on the school property, because a lot of times the predators get hold of the kids after school.
But would the rule or the theory of agency not apply here as it relates to whether it's a volunteer or a full-time
Well, they say, well, the
employee?
school says they're not an agent of mine. They're not an agent to commit an intentional tort.
So they
I don't
are-
have an agent. I have an agent who teaches children. I don't hire. They're not an agent to commit a intentional crime. So as opposed to, let's say somebody working in the school as a janitor, or somebody doing some kind of work in the school, and they improperly mop, and the child gets hurt. Well, yes, they're acting as an agent to clean the floors or to do something, or a teacher who accidentally hurts a child. Well, that's an accident, but they're acting as your agent.
Yeah, so in other words,
Nobody acts as your agent to commit an intentional tort, so that doesn't really work. What you have to show is you didn't take the steps to protect the child by investigating the background of the teacher. Negligent hiring. And what does that mean? That means you subpoena the records of the school as an attorney to see whether they did this background check. But what if they did the background check, and what if nothing comes up? So if they're difficult cases,
They are, and unfortunately, as always, of course, our time is so constricted, really, when we get into these such substantive discussions, about issues.
just
such
as a parent,
this.
so I can go really quick.
Sure.
Just as a parent, if you see the telltale signs that the child is just ignoring you, no eye contact, bruises, trust your gut. Withdrawn. Trust your gut reaction as a parent to go further and question your child or question anybody else, and ask, because the child's gut reaction is usually the best one. If the child thinks there's something not going on here that's right, it's usually not right.
And I think, too, one last point, don't blame the child.
No, it's never the child's fault, ever, in a case
protect
like
them,
this. It's the
protect them.
predator.
David, as always, thank you so much. And